Today we have Lori Namazi. Lori is a risk management consultant, mainly based out of the state of California, but has a very good connection within the National Association and has a great deal of experience. We have Lori on at the moment, and we're recording the episode very close to the release date so that therefore it is relevant. Obviously, with all the new changes that have happened within the industry, we speak about the regular questions that she's getting. We speak about circumstances like buyers wanting to not be represented, what obligation the listing agent has, and going through also and talking about situations where the buyer has asked for representation of the listing agent, only for the listing agent to find out that ultimately they'd signed another agreement. We go through a myriad of different situations and we talk about compliance in general. To those that are thinking, oh, compliance and rolling your eyes, I think that you definitely need to listen to this episode, just considering the fact that if you don't get anything out of it, just having a resource that you can reach out to somebody for is an important element. I know that it always starts with your broker, but sometimes you need an external source as well. Hopefully this helps. Welcome to Rethink Real Estate. My name is Ben Brady, and this is a real estate podcast aimed to deliver sales strategies, marketing tips, and business insights from industry experts and myself to build a listing-focused business for the future. Let's get into it. Lori, I really wanted to have you on because of ultimately the turbulence that's going on in the industry, and you know we're filming this very, very close to the release date as it to be relevant. But for those that might not know who you are and haven't read the description or anything like that, why should they hang around and listen to the episode?
Well, as a real estate professional, we're all knee deep in these new changes. And so I get tons of questions and have been asked to do lots of training on the topic surrounding what are the changes and why are we doing them. So we're going to shed some light on that today.
Wonderful. Lori, what puts you in a position to sort of give people feedback and consult to people in perspective to not only, the new changes, that is certainly something that I'm assuming is making up a lot of your day at the moment, but you were consulting well before the changes were in effect as well, based on procedure when it comes to brokerages. So I guess that where did that come from? Where have you come from? What puts you in a position to be able to do that?
Well, it's kind of been a wonderful journey. So I've been in the business over 20 years and, transitioned from a different career like a lot of people do. And in my previous career, and I was in a space of compliance and risk management and consulting. And I just sort of gravitated to that in real estate. I love this industry. I didn't necessarily love selling. So I found myself in roles at a very large brokerage in Southern California with over 1,800 agents, where I was the main point of contact, the responsible party for all of our risk management and compliance efforts. And ultimately, I was the broker for over 1,800 people, the responsible broker. So when I decided to move on and do something else to build my own legacy, I thought long and hard, do I just want to do the same job for someone else, or do I want to fill a gap that I discovered in this industry? And that gap was a bunch of my broker friends would always call me and say, what do I do in this situation? What do you think of this? So honestly, there was this gap of brokers knowing how to conduct real estate sales, but not necessarily know how to run a brokerage and what their broker supervision requirements were. So I started my brokerage consulting business in 2019. And so, yes, several years before these changes, years before the pandemic. And I've been asked on many occasions by a lot of our state and local associations to speak on risk management and compliance topics. And in addition to that, I'll mention, I've been active at the state, the local, the state, and the National Association levels for almost 10 years now, about 10 years.
This might be a little bit politically taboo, but I'd love to ask it anyway.
Okay.
Is that what is your opinion of the state and the national associations? I guess that from a positive perspective, or they govern things and whatever it may be. But are they relevant? Are they not relevant? What are your thoughts?
Well, personally, I do think they're relevant. As trade organizations, this is a place for an industry, whether it's real estate or medical, all of these different industries have trade organizations. So they have their own governing entities, whatever legal entity is responsible for governance. And then you've got your company. And again, that's the same in other industries as well. You have your company, but this is sort of a collective of resources because none of us has all the answers. And especially when you look at small companies, they don't have a lot of financial resources to really develop the tools that the state and the National Association can offer to us. And, with that too, there's this collective bargaining power when it comes to advocacy for home ownership. And it's something that a lot of people don't really realize. I never thought I would get into politics. I'm certainly not a politician, yet here I am serving at all three levels. And a lot of what we do is advocate for housing, whether it's home ownership or interest rates or different, ways this business operates. We're the advocates, and there are a lot of us, but there are not a lot of us who are the actual voice. And so that's why I serve at these levels.
This is probably an opinion that that I get from a select group versus a wider picture. So you'd probably be able to answer this better than I can. But at the end of the day, we deal with in excess of probably 2,000 or 3,000 agents a year through our non-distress auction platform, and then obviously our own internal company. I just don't believe that the associations are very appreciated, from an industry perspective, until you really need them, of course. But what do you think that they could do better in order to be more appreciated?
Well, you're absolutely right. I mean, I was in this industry for 10 years before I even had an inkling of what I was paying for or why I was paying for it. You join a brokerage and they tell you to go join the association because that's where you're going to get your MLS access. So when you look at the dollar amount that you're spending each year and in your mind you think it's just for MLS access, you don't get it. And so the only regret I have in my career thus far is that I didn't get involved sooner. I didn't learn about it. Maybe I didn't need to volunteer in those first few years or the first 10 years, but I certainly needed to recognize that there was more value there. And so I think as an association, the communication is really important. This is one of those things where it really, I believe it does start at the brokerage level to say, hey, we offer you a ton of resources and there are other resources. But I think there's this fear from brokerages. If you go to the association, someone's going to recruit you. Yeah. And so if you have that mindset that I can't let my agents out of my four walls, because if they dare go talk to another broker or an office manager, they're going to get recruited. If that's the mindset, then I think you have different problems you need to look at, because you can use the association to supplement what you're already doing and not as a replacement, and not to be afraid of what, any conversations your agents are going to have.
Yeah. I think this is more of a statement than it is a question for you, but compliance is a word that I don't think anybody appreciates until you get to the person who is either the broker or the business owner of an organization. And, it's one of the things that I probably hold at the highest element as the CEO of a company. It's the highest thing from a quality control perspective that limits your liability to a great, great, great degree. And the individual agents that are listening today, they will probably go, oh yeah, but it's just annoying to deal with the compliance and having to do this and do that. But from a broker's level, is that is the thing that allows them to sleep at night. If you've got that good process, you've got that good platform. And I think that there's something that's really missed, and there's a disconnect. Lori, I think there's a disconnect, and you probably see it better than most, is that you've got the people that, don't get me wrong, there are some people that, they live, breathe and eat compliance. And yes, they probably create way more red tape than ultimately is needed. And it does become painful for those on the other end, but to the individual agent that is listening, that is an independent contractor within that brokerage, is that they need to understand is that those little things that are in place are there not only to protect them, but it's also to protect the greater good of that individual business and us as an industry as well, because people see our industry and they just take advantage of it. And they really do. Like, don't get me wrong, I think 90% of the people are genuine in the reasons that they come and they try and buy a property or whatever it may be. But there are 10% of the people that are there, whether they be flippers, investors, wholesalers, and people that look for clear opportunities to take advantage of the E&O attribute or the insurance attribute of our business. Do you see that more often than not? Is that because our business is easily insured from the E&O perspective, is that there's more people that take advantage of it than others? And maybe, I don't know if you could speak to that.
Well, it's an interesting question, and I think there was a lot in that statement. Absolutely, I'll start with, I use the words risk management and compliance because most of my clientele are brokers. But when I do go out and speak with their agents, I have to use a little bit of different language because they don't want to hear the words risk management and compliance because they think it's just for the company. And so, what I like to share with them is when you provide all of the information to your clients and the best service to your clients, they're less likely to sue you. And I'm in California, one of the most litigious states in the country. And so, yes, we have a lot of documents and we have a lot of red tape. But when we can get the agents to understand that if you do right by the client, they're less likely to sue you, then that matters to them. A decade ago, we used to threaten, you won't get your check, you won't get your paycheck if you don't have a complete file. Now, and for the last decade, I've been talking about you need to make sure that your client has everything they need so that there's nothing they can come back to you. I mean, well, granted, they can still come back and sue you. Anyone can sue for anything, but they're less likely because they feel that you have put them first. And so that's what I'll say about, yes, the terms risk management and compliance. There's this little joke I found recently online. It says compliance people are just regulatory people. We're just regular people, but we happen to be regulatory people. We focus on that. And I just thought that was really cute. And so in terms of, why are there more lawsuits and is it easy to get E&O? Again, California and some of the other high cost states have more litigation just because there's more money. And the larger the brokerage is, no matter where they are, there's more money. So a client is not necessarily expecting to get a whole lot out of a lawsuit from an agent. They're expecting to go after the big bucks from the brokerage. And the reality is E&O insurance, just like every other insurance available to us right now, is getting more and more expensive. And E&O companies are looking at what their claims are and what their payouts are and saying, hey, we don't know about this. In California, we have a few companies that are no longer offering E&O insurance. Yeah. So our choices are limited, and that's gonna continue, just unfortunately, because we are an industry that produces, billions. I think I heard recently like $10 billion a year in just payments to people, whether they're the agents or other service providers. It's like a $10 billion industry. So there's a ton of money here.
Yeah, that's right. Well, I think that shifting gears to the issue at hand, if you like, which is, the recent changes that have gone through the industry. I want to start off with a question that we are getting a lot of, based on our general reach out to the general public that are coming through our open houses from an auction perspective, is that just to give you the cliff notes on the process, is that our Harcourts agent or our agent that is working with another company, if it's in an area external to the Harcourts business, we offer them auction. They go out and they do an open house, okay, or they go out and they show somebody the property. Their information is gathered because that is one of the requirements of auction, is that they need to provide their information if they are to enter the property, because there's a date on which the property would be sold by. And if there was to sell prior to that, we'd need to inform people. So we get everybody's information. Part of the responsibility that we've taken on as an auction company is actually following up on the agent's behalf. And, you could probably read between the lines there, is that follow-up probably isn't the strongest suit when it comes to most agents. So we need to understand where things stand from the perspective of, are we going to go to auction with registered bidders, so on and so forth? Are there offers prior to auction, everything along those lines? Now, with that becomes a great deal of follow-up. And one of the things that has shifted from, and we've got a certain team of people that follow up for all of our agents. They've got a set number of questions that are asked. They've got all of these different things. And first of all, is that the thing that is absolutely shocking is the volume of people that are coming and making a unbelievable point of saying, no, I don't have representation. And it's one of the questions that we ask, is that who's the agent that is representing you currently? No, I don't have. To see the shift in the attitude of a buyer when they go, oh no, I just came, I saw it on Zillow, to no, I do not have representation and I do not want representation. That's probably an uptick of 3,000%, okay, in the conversations that we're having. But then it's going down to the next step, which is, I want to write an offer before the auction. Great. Well, we have to have the listing agent prepare that offer for you. Okay. Well, I don't want them representing me at all. No. So one of the things that our agents have gotten into the habit of going is saying to them is, well, who's going to write the offer for you? Okay. And And have you ever written an offer before? Which I believe, Lori, and this is kind of a statement and a question, everything in one, but take it as you will, because a lot of buyers are coming in saying they don't want representation. And then a lot of listing agents are saying, well, I'm not going to represent, well, I'll represent you. And they're like, no, I don't want your representation. And they're like, well, I'm not going to do it for nothing. Isn't there an obligation from the listing agent's perspective that they need to see that through from a fiduciary obligation to the sellers? It's an issue at the moment that I've gotten several different answers from, and I'd love to hear yours.
Yeah, so we are hearing more about unrepresented buyers. We don't have any data yet to see how much of an increase that's actually going to be, how prevalent it will be in the market. But from the standpoint, if a listing agent is working for the seller and trying to get the home sold, and a buyer is insistent they do not want representation and they've documented, that's allowed. They have that choice. And so the obligation, though, of the listing agent is their fiduciary responsibility to the seller is to provide everything necessary to get to close. And that could be and is providing documentation to the buyer's agent. So to the buyer. So right now we provide it to the buyer's agent to hand off to the buyer. Well, there is no buyer's agent in that unrepresented scenario. So the obligation is still, well, seller needs to provide certain documentation. So that has to go to the buyer directly. So there's a fear that agents have, well, if I generate these forms, am I now representing the buyer? And the answer is, it's probably not. It depends how you do it. If you prepare those documents and simply deliver it to them and say, here's what you need to sign, I can't explain any of it, I can't assist you, then that is appropriate. But once they start sitting down with them and going over it with them, now you're bleeding into you're representing them. And that could be an undisclosed dual agency. So it is a requirement of the listing agent to make sure that everything is handled in the transaction on behalf of the seller. And that may be, telling that buyer, hey, well, if you don't have someone to write your offer, write down what you want to do, give that to me. It's not quite a letter of intent. It could be on a napkin and it's here's price, here's how many days, and here's my deposit. And maybe that's all they have. Give that to the listing agent. Listing agent and seller can sit down and say, okay, well, good, but not good enough. So let's write an offer. And instead of creating a counter offer, they actually write an offer, but from the seller saying, well, here's my offer to you, and put in the terms that are to the benefit of the seller, because seller has representation and gets to ask those questions. That gets delivered to the buyer, and then the buyer can decide everything looks good, or wait, we want to negotiate further.
Yeah. So it's a reverse offer, essentially. It's the same documentation, but the seller signs in advance based on the terms that are submitted in that offer in order for then the buyer to execute if they felt it. So I think that, from a sense perspective, like we've operated in many other countries across the world, and, at the end of the day, the US is still the only place that we've ever operated with buyer side commission, and which again was a positive for us when we came here in the very first degree of it. But we are so used to the fact that, getting that question, a buyer goes, I want to write an offer, the listing agent writes that offer, okay, submits it then to the seller. Is that like the liability question doesn't come into play because I'd go as far as to say 80% of the other countries that we have operated in, it works as a sort of a non-disclosure sort of state. Like I know, and again, you're gonna have to forgive me if I'm getting this wrong. Is that I think Alabama works this way because we recently were asked to do an auction there, and I said, well, with our auction process, we need to do all the reports and disclosures up front: home inspection, termite, everything that would normally be done within the escrow period or when it goes under contract in the inspection period needs to be done up front for anyone to do an auction. And the seller turned around and said, well, I don't want to do that. This is a non-disclosure state. If the buyer buys this property and they don't do their own reports and disclosures and reports on the property and everything in their own finding, then ultimately, at the end of the day, it's on them. And that is how 80% of the world works when it comes to real estate transactions, apart from the US, in many of the other places. So it sort of made sense in the sense that, it's on the buyer to do the due diligence. But getting back to the legal side of it and getting back to the form side of it, speaking specifically to the California Association of Realtors, is there a form that the listing agent can have the buyer sign that stipulates that they are not being represented and the listing agent holds no liability to anything that they're giving the client giving the buyer?
Yeah, there is such form. It's a buyer non-agency. I like to say that if you can dream of a form in California, we probably have it, and we do. And it is pretty clear that any work that the listing agent is doing is strictly on behalf of the seller.
Yeah.
And for other states, there are different agency laws and requirements. And so the settlement is for the entire country. There are a few caveats in there that say, here's what we're expecting, but check your local laws because the local law may be more restrictive.
Yeah, that's right. And I think that that's one of the things that anybody that's listening to this at the moment should get very familiar with is that individual document within their individual area that they're obviously in, because they'd be different for individual associations and everything like that as well. But steering further into where you are at the moment, because if the agent and the broker is knee deep in this problem, you're up to your neck in it. With the questions and everything that you would get. What are the most common things that you're seeing as questions from agents and brokers? But then also it's a two-part question. What are you seeing? But then what are the things that you're seeing people not thinking about?
Wow, those are really good questions. So, in terms of what I was expecting to hear, it's not as crazy as I thought it was going to be. We were anticipating the wild, wild west, and luckily, in my area and in my clientele and the circles that they're in, it's not as crazy as we were expecting. So I think for the most part, at least in California, a lot of people understand, hey, this is how it is now. And the questions that we're really getting is, basically, did I do this right? I have a broker might ask me, one of my agents, they told the seller, no, we're not going to do this in the listing contract, but the seller insists. So how do we document it? How do we fulfill the client's wishes and still comply with the settlement and then with our state forms? In our state forms in California, we took it a step further and said, we're just not negotiating buyer agent compensation in the listing agreement at all. The forms were created in such a way that negotiation by the listing agent and the seller on behalf of a buyer's agent is not able to be facilitated in the documentation. Now, the settlement does allow for cooperative compensation. It does allow a listing agent to take a total commission and share it. But our forms in California don't facilitate that, simply because we're anticipating that's where this is going. That's where the Department of Justice wants to take it. Let's just get ahead of it and eliminate that. It is allowed in other states. So I want to be clear that, the resources you'll see from NAR does reference cooperative compensation, but in California, our forms don't facilitate that. We do know that there are brokerages that are still doing that. They're just documenting it on their own documentation. So in terms of, the questions we're getting, it's really, am I doing this right? Did they use the right form? What about open houses? I think open houses had been the greatest question for a while, the one we got the most, because there was this confusion of, well, what does touring mean and what does working with a buyer mean? Because those were key words in the settlement, touring and working with. And so understanding the definition of that, I use this analogy. If you go to a gas station and you're there to get gas, you're there for the service and the product that's available. If the gas employee, the attendant, pumps your gas, that's working with you. But if you pump your own gas and you don't ask the attendant to help you, then that's unrepresented. So you can go to an open house and not have representation. You can simply walk in the door and look around without that host, and I'll call him the host rather than the listing agent, because it could be someone on a team, someone else in the brokerage. That host is not necessarily working with or touring that buyer if that's not the relationship that is being built, because you've asked the question at the door, who's representing you? Yep. And so those are probably the most questions we've been getting lately. And, I guess the other question would be, buyer's agent and buyer negotiated a compensation, asked the seller to pay it. Seller has negotiated down. What do we do now? What documentation do we need? So in my area, it's more about what's the proper way to fill out the form. And it's a little less on actual, how do I handle this with clients? How do I talk to them? What do I do?
Yeah. Well, I guess that the thing that I am probably, again, to use your terminology, not shocked with, or I think the industry is a little shocked that there hasn't been a bigger reaction to what happened. It's one of those things that got blown out of proportion, in the sense that, oh my God, this is going to change absolutely everything. It just obviously creates another talking point with everything. But the thing that I'm the most curious about from a compliance perspective overall, Lori, forgetting the changes and everything along those lines. What is something that you see agents and brokers / brokerage do that is probably one of the things from a compliance perspective that they sort of lack? Does that make sense? Like what are people lacking in from a compliance perspective across the entire transaction that you go into most brokerages or go and consult with the individual agents and see them doing more often than not, that is probably going to lead to the biggest element of liability?
So I would say it's twofold. The first being most brokerages do not employ their agents, they're independent
Right.
contractors. And
Right.
because they're not employees, they're not all clocking in at 9 a.m., attending the staff meeting and going home at 5 o'clock. So there's this big disconnect. We love the freedom of having the independent contractor status, but the burden on the broker for their broker supervision is huge because we are not with those agents every day. We can't mandate them to come to a meeting. And so there's a disconnect in training and in communication. And I was a broker for a large brokerage. I had multiple layers of management. I mean, I probably had 40 management level personnel who could interact with the agents in the field. And yet I know without any doubt, 1,800 people were not getting the memo. It's just a reality. And so that's a big disconnect. And that's one of the challenges. It doesn't matter how many layers of management you have, unless you are consistently and systematically reaching out to every single agent and making sure they got the memo and they read the memo. More important than getting it, that they read it and they understand it. You're always going to have sleepless nights because you don't know if they know and you don't know what they're doing. And then in terms of an actual transaction, where I see the biggest gaps is essentially kind of falls in that same line, is agents are talking to their clients and we don't know what they're saying. We don't know that they said it appropriately. We don't know if they said something that's a violation of fair housing or against licensing law, or what promises they made and now they can't keep them. So that's a huge difficulty for us. And when we don't have things documented, if we had a Department of Real Estate investigation or a lawsuit, not everything is in writing. And the file, whether it's electronic or paper, doesn't matter. The contents of the file tells the story, and there's always gaps. And so, this isn't unique to our industry. This happens in any business. There's, you didn't raise every person that works for you, so you don't know what their belief system is and their level of organization. So it's not unique to us, but it's prevalent, and I think even more so because they're not employees.
One of the things that's sort of popping into my mind at the moment, Lori, and I want to come back to the brokerage here in the moment, and I want to talk to you about what's your sort of step-by-step process if a brokerage or came in and they asked you for your services, like to assess their risk essentially, or assess their process, how you would do that. But I want to go back a step here for a second. Something that I wanted to ask you, but I didn't, is that there was a situation the other day where we had an agent reach out to us from internal to our group saying, I had shown the buyer the property. They'd come through the open house. They wanted to go back for a second showing. They went back through for the second showing. They let them in. They showed them the property. They then wanted to make an offer, and they wanted to write an offer with them. And they did write the offer with them. They took them all through it. The seller took it. They accepted it. But then the buyer found out that they'd signed a buyer broker agreement that was for a term or a period with another agent, and the other agent reached out saying, "Hey, that's my commission. I should get that. That buyer is mine," essentially. And again, I don't want to speak to the specifics of the document myself because I don't know them, but all I know, it was for a period of time or an exclusivity period of time with that buyer. It wasn't for a particular property, I believe. But long story short is that agent is claiming that buyer's mine. I want that commission. And at the end of the day, we didn't know how to handle it until we obviously reached out to the appropriate places. But from your perspective, have you seen that? How would you handle that situation?
Well, it's going to continue to happen until, as an industry, we get really comfortable with explaining to buyers that potential scenario,
Yeah.
that they need to know what they've signed. And it's okay. It pains me to say, but it's okay if they sign multiple agreements, but they need to be really clear with what their obligations are for each agreement.
Yeah.
If they are looking at one agreement for specific properties, that's fine, and then they sign a different agreement for other properties, that's okay. The way that procuring cause used to be handled, where if you did not have a buyer representation agreement, it was between those agents who really assisted the client. And when commission was offered on the MLS, it was pretty clear that's a contract, and so
Mm.
the seller would have to pay that buyer's agent. Now, that previously would have been a agent to agent procuring cause claim. One agent saying, "Hey, I was the representative, someone else wrote the offer." Now it's going to be that agent who has the agreement with the buyer. They're going to need to go to the buyer and say, "You owe me." So it's no longer agent to agent, because that commission is not a contract between agents in an MLS. It's now buyer and buyer's agent have their own agreement. So when you are writing a buyer representation agreement with the buyer, you need to make sure you explain to them, "Hey, if you have signed other agreements, which, ours, let's say ours is not exclusive, so you can sign another agreement with someone else. But we need to be really clear. What properties did you look at with that previous agent? Let's list those, because I don't want to interfere with that, because I don't want you to pay twice. And I'm not
Yeah.
going to show you those properties. I'm
Yeah.
going to show you different properties." So until we get really comfortable with explaining it to the buyers, we still could have this issue, but it's going to now be the agent who has a contract approaching their client and saying, "You owe me the commission," versus approaching the agent and the listing brokerage.
Yeah. A solid point is that we just need to get comfortable asking those type of questions before we
Mhm.
invest our time into those situations. Now,
Absolutely.
Laurie, leading back to that next part of this to sort of round out the podcast, I want to sort of understand, a brokerage says, "Hey, I need your services to come in and help us from a compliance perspective or risk management perspective." What is the process that you go through with that brokerage in order to assess that and then to put the processes into place? Because to lead off something that you said earlier in the podcast was most of the problem comes back down to the communication of that memo to make sure that the agents ultimately did get that. Is that something you're helping with? Are you helping with more frequency and training, or are you just helping with process in general? How does it look when you're sort of brought into the equation?
It can be any combination of those and even other things. So when I'm introduced to a broker, we sit down over Zoom and we talk about what are their challenges, what are their needs. And some, they're all at different places. So some have a very solid infrastructure and they're really just looking for somebody to reach out to for operational support, transactional support, and things of those nature. If they are newer and they don't have that infrastructure, then we build the infrastructure. And so really it's customized to where they are in their business, and it evolves over time. You might see a broker go out on their own, they're ready to be on their own, they need the infrastructure to be a broker on their own. The moment they start adding agents, things change. And as they get through different phases of their growth of their brokerage, their needs change. So it really depends. We sit and kind of talk through, what are the challenges right now? What are the goals? What do you feel you're lacking? And then I try to connect them. Sometimes it's a matter of connecting them with other resources as well outside of my services. But when I'm meeting with my broker clients, and when we mentioned about the communication, we look at what is their system for communicating to their agents. And as I mentioned, you can't be with these agents 24/7. You're not going to hear every conversation.
Yeah.
But you as the broker need to be able to demonstrate you made the effort and you made it repeatedly, not just one time. So it's showing that as part of your operations, you have systems in place to do that regular communication and methods of ensuring they get it, whether it's a read receipt or you make them sign it and email it back to you and you throw it in their file. It really kind of depends on, what the item is as well. But we look at, can you can you actually demonstrate that you have supervised, that you're actively engaged? And someone who cannot demonstrate that they're actively engaged and they're basically, just being paid to use the broker license, they're going to be found out if the Department of Real Estate or equivalent comes knocking on their door.
Laura, it's a wonderful point, and just final statement on that before I ask you about some resources that people could use, including your own services, is that we had a situation a couple of years ago, well before COVID actually, where the do not call register became a problem for us in the sense that we have independent contractors that ultimately, it's the same as the real estate transaction. It's funny because we have Harcourts International as one of our companies that is here in the US. That is the first one that always gets the first lawsuit for any of our Harcourts offices because they believe they want to go straight to the top. The interest, as you mentioned before, obviously. But the funny part about that is that with the do not call register is that it's funny, as independent contractors, we're not allowed to tell them what to do, okay? And ultimately agents were calling, do not call numbers, and therefore it led all the way back up to the brokerage. And this is where I want people to understand this for a moment, is that when somebody sues you from an offense like that, is that it's uninsurable. You don't have the appropriate insurance. There are some insurances that you can get that are there for that, but realistically, no brokerage really would ever typically think about carrying those outside of E&O because of those transactions. But all in all, it came back down to the attorneys and all of the legal stuff getting targeted towards the brokerages that those agents were in. And they would never go and put the suit on that individual because they know that the individual either doesn't have enough money in order to cover it or isn't a viable source to get that. So therefore, it always stuck with the brokerage itself. And it's one of the really important elements when you go to choose hiring certain individuals or certain people is that you need to look at their individual practices before you fully commit to that person. And it leads all the way from the hiring all the way through to the way that you communicate that through the organization, which I think that your skill set is invaluable. And a lot of people probably don't appreciate it as much as they should. So first of all, I wanted to say thank you for the people that you've helped within our organization, but also from an industry perspective, you're sort of helping clean up that industry because there's not a great deal of people that are out there doing what you're doing because it isn't the most sexiest thing to do in the world, right?
Right.
So
I love
leading,
it, right.
I'm sure. But I'm leading into the questions of resources now. Is that, from an individual agent perspective that does want to be buttoned up with this because there are many, many, many out there that do. And then also from a broker's perspective, obviously there's your services. You put out a newsletter on a regular basis that I get. I really enjoy that. But then also is that there's other external stuff as well. Where would you steer people towards from a resource perspective?
Well, first and foremost, go to your broker. Your broker is your first point of contact because while there are state regulations and different laws, sometimes the implementation can vary from broker to broker. And so you need to make sure that you know what your broker expects. And when I do presentations for an office, I numerous times will explain, but check with your broker on this. And I try to be aligned with that broker's philosophy. The next thing I would say is make sure within your office you've got a culture of integrity and asking for support. And although we can't necessarily mandate everything, we certainly can require that per our contracts with the agents that they follow our policies and procedures. So as long as your policies and procedures don't tell them how they have to go do business, how they need to find their business and that they need to clock in and clock out, you can still have very specific policies and procedures on how we operate as a company because that is allowed. Now, in terms of resources beyond your brokerage, then I would say look at your local and your state associations. Their websites are full of information. NAR is another great website to look through, specifically related to the industry changes. The website is facts.realtor, facts, F-A-C-T-S.realtor, and you can get tons of information there. But again, it's general for the entire country. Your state might be a little more restrictive. But the state associations are probably one of the best resources because they are going to be the ones that have all the state specific information and can direct you to other links as needed. Yeah. And so, I think that's all of them.
Do you have any?
MLS and your MLS. Your MLS will have rules too.
That's right. Do you have any podcasts or anything? So from a more visual, more audio perspective that you've heard of or listened to? Again, sorry to put you on the spot with that if you don't, but because I don't know many that are as they're I don't know they're not very specific.
I'll have to give that some thought. I know there is one that I can't think of the name of it, but James Dwiggins does a really great podcast. I just can't think the name of the actual podcast escapes me. And our state association actually has a number of different podcasts as well. And again, specific to California, though, there is a couple of NAR podcasts, but they're more generic as well.
Yeah, that's right. Well, Lori, thank you very much for joining us on Rethink Real Estate. It's again been a very valuable thing to have you on, and it may be something we continue to do so that the community can understand, from a compliance perspective, the things that are changing. But either way, appreciate you being on today, and thank you for my terminology, cleaning up the industry a little bit from a compliance perspective, because you don't really appreciate it until you're in it.
Well, I appreciate the opportunity to chat with you and to be able to spread the word. I mean, that's what it's about. We are a self-policing industry and we have to help each other. So, as an industry leader, I'm compelled to make sure I can just get the word out there and help those better understand so that we all can do better.
Thanks, Lori.
Thank you.
So about 75% of our audience hasn't liked, followed, or subscribed to our podcast. It would mean the world to us, and it would help this podcast more than you know to expand our reach if you were to like, follow, or subscribe on any of the platforms that you're watching or listening on. Thanks again.